In today's video, we're going to be discussing arbitration. If you don't know what that term is, today's video is definitely for you. And if you heard that term synonymous with mediation, I want to let you know that it is not the same thing. So in today's video, we're going to take a bit of a deep dive into arbitration. We're going to talk about some crazy statistics when it comes to arbitration. And you're really going to learn today in what side of the fence you stand on. Do you stand with the plaintiffs and say no to arbitration? Or do you stand with defense and say yes to arbitration? We're going to find out today in a yes or no question game that I've got in today's video for you. So if this sounds like something that you'd be interested in, stay tuned and let's dive into things today. First and foremost, I would like to thank President Biden for signing into law the bill ending forced arbitration in sexual misconduct cases. I'm talking about sexual harassment, sexual abuse, and these are things that actually happen in the workplace. And people who filed claims and filed lawsuits claiming sexual abuse and sexual harassment in the workplace were forced into arbitrations due to dispute resolution agreements buried into the fine print of employment agreements that they had signed when they first came to be employed at that company. And of course, you probably didn't even know it existed until you found out that your lawsuit was being either dismissed or stayed due to an arbitration clause that was buried in the fine print. So let's talk about arbitration and let's figure out what side of the fence you actually stand on. So there is a common misconception about the word arbitration, and that's the fact that it's agreed to. In most interpretations and definitions of this word that you'll see across the internet, you also see the words agreed to, and that's simply not the case. In rare forms is it ever agreed to. So while I was doing some research preparing for this video, I came across some staggering statistics that I didn't even know it existed, and I'm sure that you don't, and I would like to share those statistics with you. 55% of workers are bound by an enforced arbitration clause in the employment agreement that they sign. 55% of all employees are bound by an arbitration clause that they probably don't even know exists. 93% of all banking entities used forced arbitration clauses in their checking agreements. That is pretty standard these days. 93% is a pretty big number. So if you have a dispute against your bank for something that they kept or something that they charged or something that happened, you're not going to get your day in court unless you can fight that arbitration clause. You're going to go into forced arbitration right away. 81% of America's largest consumer companies have arbitration clauses buried somewhere in the fine print of all of their agreements. If you have a consumer dispute, rest assured it probably won't end up in court until you fight a forced arbitration clause. So why are big corporations including arbitration clauses in the fine print of the agreements that they have people sign or terms and conditions that people agree to, like the ones you're agreeing to whenever you play an online video game? Well, in order to find out the answer to that question, let's play a little yes or no game. Let's find out what your opinion really is and which side of the fence you actually stand on when it comes to arbitration. Yes or no, answer these questions, and at the end of these questions, you'll probably know which side of the fence you actually stand on. All right, here we go. It is easier to convince a sole arbitrator of the claim versus a panel of jurors. Yes or no? Arbitration helps to avoid the sideshow from plaintiff attorneys that cause runaway jury verdict awards, add cost, and waste time. Yes or no? Arbitrators focus on facts, while jurors focus on sensationalism. Yes or no? Most jury trials last 1 to 3 weeks, whereas arbitration typically lasts 1 to 5 days, thereby saving time and money. Yes or no? Now, quick intervention here. Getting to arbitration does not take 1 to 5 days, just like getting to trial doesn't take 1 to 3 weeks. There's a lot of time leading up to both of those things, but there is less time leading up to arbitration, of course, than there is leading up to trial, because the whole point of burying those arbitration clauses in the agreement's terms and conditions is to avoid the time and cost of litigation and also to avoid the panel of jurors. My research showed that at the end of the day, corporations experience a win rate of approximately 85% when they go to arbitration versus trial. So let's take a look at the top 10 corporations who enforced arbitration clauses and agreements made for all employment and consumer disputes. Whether or not those were pre-litigation or going into litigation, let's look at the top 10 results. So our first category here is going to be in employment disputes. Now remember, these disputes are about sexual harassment. These are about termination clauses. These are, wrongful termination. Think about your employment disputes, labor and wage. So let's look at these top 10 defendants. Here's your list right here of the top 10 defendants. Family Dollar Tree claiming the number 1 spot in 2020. We're talking the height of the pandemic. In 2020, they claimed the number 1 spot in enforcing arbitration clauses in employment disputes. Next, we have the Dollar Tree. Now, Dollar Tree and Family Tree are owned by the same entity. I believe Dollar Tree is is the parent entity, I believe, of Family Dollar. We have TBC Rental, Big O Tires, Tire Kingdom, Menards, Chipotle. We love Chipotle. It's one of our favorite Tex-Mex restaurants. I love Chipotle, but in 2020, they claimed the number 5 spot in enforcing arbitration clauses in their employment agreements. Next, we have Charter Communications, also known as Spectrum. People on the East Coast will know who that company is. We've also got CoreLogic, Macy's, eTelequote Insurance. Of course, there has to be an insurance company on the top 10 list, and Halliburton. So those are the top 10 people in 2020 who were enforcing arbitration clauses in their employment agreements. So let's take a look at the consumer side and take a look at the top 10 corporations who were enforcing arbitration clauses in consumer agreements, terms and conditions. Here we have them. We have claiming the number 1 spot, of course, Family Dollar. That has been across both of our lists. We have Windstream Communications, AT&T, American Express, Western Culinary Institute, also known, I believe, as Cordon Bleu. It is a culinary institute that wasn't exactly doing what they were claiming to do. So anybody who sued them was forced into arbitration. Of course, we have Tinder on here as well. Tinder, the Tinder swindler. I don't know if anybody has seen that documentary. I haven't yet. But there's also corn applications, American Home Shield, which is actually my home warranty company. I was not excited to see this on the top 10 list. And we have Citibank and Charter Communications, also known as Spectrum. Again, on the other list as well. So employment disputes, consumer disputes, we have Family Dollar and Spectrum, who is across both of these lists right here. And Family Dollar, I was a bit surprised to see them on the list because I really thought that during the pandemic, they were going to come out, for the people and help the people, being Family Dollar, but no, they are a top 10 corporation in enforcing the arbitration clauses, especially during the height of the pandemic. So due to some heavy fees that big corporations had to pay in those arbitration disputes during 2020 and going into 2021, a lot of those big corporations ended up dropping those forced arbitration clauses within the agreements. Companies like Facebook, Amazon, Airbnb, Google, Uber, and even Microsoft said, drop it like it's hot. Those arbitration fees are way too expensive. And then on the flip side, you had corporations who were weaponizing their arbitration clauses buried within those agreements. During the height of the pandemic, instead of scaling back, they chose to weaponize these clauses instead. So if you want to know who those companies are Twitter, Square, StubHub, Marshalls, TJ Maxx, and over 70 auto dealerships are now putting arbitration clauses within the agreements that you are required to sign. And I know that you're not signing any agreements at TJ Maxx or at Marshalls, but I bet you if you look on the back of your receipt, you are going to find some new arbitration information on the back of that receipt. So while I applaud President Biden for making sure that people who are victimized by sexual assault and sexual harassment in the workplace are no longer being forced into arbitration, I still think that we as a society have a very long way to go. Enforced arbitration clauses and agreements when it comes to long-term care and senior assisted living centers. We do not need arbitration clauses in those agreements. That is a moral dilemma. So here are the unfortunate facts when it comes to enforcing arbitration clauses in agreements that are buried in the fine print of senior living facilities. For assisted living settings, entities are allowed to make arbitration a mandatory term for the admission contract. It means that no matter what, they're never going to get a jury of their peers. They're always going to be forced into arbitration. The CMS rules, which is the Center for Medicaid and Medicare Services, do prohibit mandatory arbitration clauses within their agreements, and they do require that such agreements be voluntary. However, most nursing homes have also adopted the Federal Arbitration Act, also known as the FAA, which allows nursing homes to have arbitration agreements despite state law on the premise that federal law preempts state law. Which it does, but again, think about the moral dilemma that we face here as a society, requiring these people to sign arbitration clauses within those agreements. I mean, if you're coming from the hospital in this horrible circumstance where you have no choice but to go into long-term care and your designee or your power of attorney is signing these admission agreements on your behalf, then you're forced into a situation because you really have such a lack of choices there. Most people don't even know that they are signing admission agreements that have enforceable arbitration clauses within them. So again, thank you, President Biden, for all that you've done. But we still have a long way to go in ending forced arbitration agreements. I feel that most influencers today don't really stand up for causes that they believe in because they think that they're going to come out and be too controversial. Controversial or not, I don't care. I stand with the American Association for Justice when I say end forced arbitration clauses, end forced arbitration agreements in long-term care senior living. If you are a paralegal working with plaintiffs or working with an attorney who only works with plaintiffs, then I encourage you to become a paralegal affiliate of the American Association for Justice and join us in the fight to end forced arbitration agreements and forced arbitration clauses. Thank you for watching today's video. If you liked it, please give me a thumbs up and subscribe if you haven't already. Consider clicking that bell notification to receive a notification each time I post a video on here. Of course, good luck to you and all that you do, because this crazy legal industry needs an amazing paralegal who has a voice just like yours. Thank you so much for watching me today. Support this cause. Go out and support your own causes and don't be worried about the controversy. Thank you. Have a wonderful rest of your day, an amazing work week ahead of you, and I will see you guys back here on the next one. Bye, guys. Mwah!